We are the PBA, heirs to a glorious past, kindred and noble purpose, to blaze the future's path. Let us be the shield against lies and oppression. Let us be the light to bring justice home. Through time we have stood constant, faithful to our oath, champions of the oppressed, guardians of the truth. Under our watch, let no one be denied. Under our watch, let no one be deprived. Our fight for justice is a fight that we shall wage with fervor and honor to the very
Yeah, it makes me want to cry. It's beautiful.
So I think we could start.
Yes.
Okay. So good afternoon, everyone. Welcome to the first collaboration of the Philippine Bar Association and Law Asia. There is no doubt that businesses today heavily rely on data. Data flows from one country to another. But the question is, are we familiar with the rules and regulations on cross-border data transfers? So we are here today to discuss localization and cross-border data transfers, the Asia update. To all our guests, this webinar is being recorded, and the recording will be made available by the PBA and Law Asia. Feel free to contact us after this webinar. To ensure the smooth flow of our webinar, please save your questions for the Q&A portion. Type your questions in the chat box. But if we run out of time, you may freely contact any of our panelists. Their contact information will be displayed on the screen as well. Please keep your mics muted and let us try not to distract our panelists during their presentations. So let me do a quick intro of all our speakers. The opening remarks will be given by Ernestine Carmen Jo Villarreal Fernando. She's the president of the PBA, an experienced litigator and corporate attorney. For the law updates for Indonesia, our speaker is Johannes C. Sahetapi Engel. He's the founding partner of Accent Law, and he is well adept in cross-border transactions, having represented multinational, regional, and local investors, and having practiced in Singapore and is currently practicing in Indonesia. For Singapore, we are pleased to have one of our Singapore's leading privacy professionals. She is Sandy Chan, Senior Privacy Counsel of Shein. She is certified with the International Association of Privacy Professionals as a Certified Information Privacy Professional in Asia Privacy Law and a Certified Information Privacy Manager. For the Philippines, we have Ms. Maria Laarni Viñas, the Legal Director of Shusaku Yamamoto, an intellectual property, technology, and corporate law firm based in Japan. Even if based in Osaka, Japan, Laarni continues to keep herself abreast in developments in the Philippines. For China, we will hear from Lindsay Zhu, She's a partner at Squire Patton Boggs, and she's based in Shanghai. She advises both foreign companies operating in China and Chinese companies operating outside China. She's an expert in cross-border M&As, joint ventures, and other commercial transactions. For Australia, we have Natasha Sim. She's a senior associate of Russell Kennedy Lawyers, and her practice focuses on employment law and workplace relations matters. After the presentations for each jurisdiction, we will have a summary to be led by Scott Warren. He is a partner of Squire Patton and Boggs. He's based in Tokyo, and he leads the team that specializes in cybersecurity, data privacy, and digital data disclosures. Scott advises on digital compliance, e-discovery, and corporate data privacy for global and local companies representing a varied spectrum of industries. For closing remarks, we will hear from Dr. Sunil Abayeratne. He's the chair of the Communications, Technology, and Data Protection Committee of Law Asia. He is a senior attorney on intellectual property of C. Matthew and Company, a firm in Sri Lanka. He's not only an attorney, but he is also a justice of the peace and an unofficial magistrate. So to officially start our afternoon's webinar, I now call on Attorney Villarreal Fernando.
Thank you, Chrissy. Good afternoon, everyone. I am Ernestine Bingbing Villarreal Fernando, President of the Philippine Bar Association. On behalf of the Philippine Bar Association and Law Asia, we welcome you all to this landmark webinar on a topic close to the hearts of many of us here: localization and cross-border data transfers. Asia Update. This webinar brings together foremost experts and private practitioners in data privacy from 6 jurisdictions: Indonesia, Singapore, Japan, Australia, China, and the Philippines. In this era of practically instantaneous state-to-state access to information, and at times disinformation, the discussion at hand is relevant in learning what the expectations of one state vis-a-vis the other states are in observing the privacy of data. The discussion also seeks to anticipate means by which differences in state requirements for transmittal will be more efficiently addressed. Creating and providing the opportunity for this dialogue also continues the Philippine Bar Association's notable service to its members, as well as to the Philippine and to the international communities, to provide a relevant and reliable legal foundation, well-studied anecdotal experience, and cases through professionals. And these professionals have direct linkages with the subject at hand. In this way, the Philippine Bar Association remains constant and true in upholding the rule of law. This webinar is also another venue for the intelligent and respectful exchange of ideas, venues that the Philippine Bar Association has provided its membership for over 132 years. We thank the Board of Trustees of the Philippine Bar Association, the members of the Philippine Bar Association, the PBA family and community, Law Asia, the panelists and participants, and the team that brought this webinar together. We thank you, the attendees, for taking the time to join us in this course. We trust that we shall all benefit from the coming conversations. Thank you and good afternoon. I pass the screen now to Mr. Johannes Sapetahi Engel.
Thank you, Bingbing. Thank you, Philippine Bar Association and Law Asia, for the opportunity to participate in this event, and thank you as well for fellow speakers and moderator Scott Warren, and also the participants, of course, for taking the time to join this event. I'd like to go through quickly about the data localization and transfer in Indonesia. May I have the slides, please? Thank you. Next, please. Yeah. Okay. Next, please. Yes, we will begin with the relevant regulations, and here I list down the relevant regulation regarding data localization and transfer. Next, please. So if you look at this, the first law that came into effect was in 2008. So it's been quite a while. The data rules and laws about data have been since 2008, and then in 2022, October last year, the personal data protection law was issued after a long time of deliberation at the parliament. So this is the list of the laws and regulations that are relevant to localization and transfer of the data. Next, please. Okay. Next, please. Like it under the other perhaps like in other jurisdictions, in Indonesia, we have what we call electronic systems operators, or ESO. Now, there are two types of ESOs: private ESOs and public ESOs. Public ESOs deal with government-related functions, and private ESOs deal with private matters. Okay, and for each, there are different requirements. For private ESOs, there is no requirement for an ESO to have the data localized in Indonesia. They could have data stored outside Indonesia. But for public ESOs, the data must be stored in Indonesia, except in situations where there is no technology that would allow a public ESO to store the data here, which I don't think that could be an issue at the moment, because at this stage now, we do have the technology to have data centers in fact, there are a number of data centers of international companies in Indonesia as well. Next, please. While it's, oh, sorry, can you go back to that? While it's not necessary for private ESOs to have their data centers in Indonesia, they do need to ensure that there is effective monitoring and supervision by the government. And also they must appoint a representative domicile in Indonesia to be the ESO representative, so that if there is any request or any question by the government, there is a person that could respond to those questions. Okay. In certain sectors, particularly the heavily regulated financial industries, bankings and non-bank financial institutions, the data centers must be within Indonesia, okay, together with their data recovery centers, except approved otherwise by the OJK, or the Financial Services Authority in Indonesia. Next, please. Next, please. Let's talk about transfers of data now. Yes, domestically, it's okay for controllers. Now, the reference to controllers and operators are in the PDP law, or the Personal Data Protection Law, which was issued in October 2022. Domestically, data may be transferred between controllers, so no issue, as long as they comply with the principles of personal data protection under the PDP law. Now, overseas, there are certain requirements where a transfer may be done. One is the country receiving the transfer has an equivalent or higher standards for data protection compared to the PDP law of Indonesia. If the condition is not met, then controller or the sender, the transferor, must ensure that there is adequate and binding personal data protection instrument when the data are transferred. If those conditions are not met, then the consents from the data subjects are required before we're able to transfer the data to outside Indonesia. Next, please. Just want to touch base a little bit on some case law. Although Indonesia is a civil law jurisdiction where previous court cases are not binding on courts, but it is still good to look at that as references. Next, please. Okay, so first and second bullet point deals with the sanctions or for violations of transfer of data without consent, or if the transfer violates other rules and regulations. So any transfer domestically that violates the law may subject the company of imprisonment up to 12 years and or a monetary fine of up to 1 billion rupiahs, roughly $750,000. Now overseas, okay, country, if the country that received the data does not have the equivalent higher standards, then that would be a violation. Then the sanction could be a written warning or temporary suspension of data processing and erasure of data, and also other administrative sanction, including revocation of business licenses. There was a case not long ago in 2020 that involved a violation of Article 27 of the EIT law, the Electronic and Information Transaction, which contained a transfer of data or use of data that contains some extortion or threats, and the perpetrator was convicted of 1 year imprisonment and a fine of 70 million rupiah. So in short, the law is implemented, is enforced, and sanctions are given to the violators of the law. Next, please. Yeah, that was it. So if there are questions later on, we'd be happy to take them on. Thank you very much.
Hello, everyone. Thank you. Can I have my slides up, please? Thank you. Thank you. So good day, everybody. I'm Sandy Chan. I am a qualified advocate and solicitor of Singapore, and I spent the last decade of focusing on data privacy, law implementation, and compliance at companies like Shein, ByteDance, and Rakuten. So it's my privilege to be invited to provide the Singapore update for this topic today. So generally speaking, right, I will take a step back and I'll look at Singapore's privacy law, generally speaking, first. So Singapore takes a very interesting approach to privacy, and it's actually a very business-centric one, right? You have to see it in like the greater landscape of Singapore's strategy, right? Positioning it as a business and a digital hub. And this comes out, in Singapore's attitude towards data localization and data transfers. So from a regulatory perspective, data localization and cross-border data transfers are different goals and use different mechanisms to accomplish these goals. But they have a lot of overlapping concepts, and sometimes they come across as opposing concepts even, right? So data localization measures either prohibit data flows or enforce local storage and processing, whereas data transfer obligations allow for data to flow in a protected and safe manner, right? Next slide, please. So one is Singapore's approach and perspective to data localization. Singapore's PDPA, right, does not require personal data to be localized in Singapore. So for this part, I will focalize more on like the regulatory landscape that Singapore, you can tell from Singapore's regulators. For Singapore, data localization is not just a privacy regulatory issue. And as mentioned, Singapore advances itself as a business and digital hub. So various Singapore regulators have been very vocal in saying that they will do their best to discourage other jurisdictions' regulators from creating generally applicable data localization requirements. In fact, the MAS, the Monetary Authority of Singapore, which is our financial services regulator, has explicitly stated that data localization requirements can increase cybersecurity and other operational risks, and it can hinder risk management and compliance. So they have taken a very, very kind of direct approach to say that we discourage data localization, not just in Singapore, but with other jurisdictions as well. And this is also visible in our bilateral treaties. So next slide, please. Oh, sorry. So Singapore's digital economy agreements is something that our Ministry of Trade and Industry has led and conducted negotiations on, and we have actually got 5 of them with other countries like Chile, New Zealand, Australia, United Kingdom, Korea, and also the EU, right? So while these treaties are bilateral treaties, these are like agreements between the different governments to show that we will try to reduce the amount of data localization requirements in between the 2 countries, and hopefully that will be visible in each country's privacy laws. For Singapore, if you know about the Singapore PDPA, the legislation is structured under 11 different obligations. Section 26 of the Singapore PDPA is basically what we know as the transfer limitation obligation. And this is what we can see from the slide here. So in essence, the obligation is to ensure that organizations provide a standard of protection to personal data, so transfer that is comparable to the protection under the Act, which is the PDPA, right? And you can tell that Singapore's policy on cross-border data transfers leans towards protecting data through data adequacy requirements. And data is restricted from going on the world tour. So this comic here is actually produced by our PDPC, our regulator. So unless the organization ensures that a standard of protection equivalent to the Singapore PDPA is provided to personal data that is under its scope, right? Next slide, please. So data transfer agreements and binding corporate rules may be familiar concepts to most privacy professionals, practitioners, especially those that are familiar with the GDPR version of things. But there's a difference, right? In Singapore, we do not have standard contractual clauses, right? And in our binding corporate rules don't need to be approved by our regulators, right? So it's mainly reliant on companies assessing and ensuring that they're legally enforceable and a standard of protection equivalent to the PDPA, the Singapore PDPA. And of course, if you come under regulatory scrutiny, this is something you have to prove. In fact, the fact that it's legally enforceable. Right. So the APEC, CBPR, and the PRP, these are, the Asia Pacific Economic Cooperation cross-border privacy rules, and the APEC, privacy recognition for processes system. So this is a government-backed data privacy certification that companies can join to demonstrate compliance with internationally recognized data privacy protections. This being said, not every APEC country is actually has signed up to the CBPR system. At the moment, there are 9 economies, so the United States, Mexico, Canada, Japan, South Korea, Singapore, Chinese Taipei, Australia, and the Philippines that have signed up to this CBPR system, right? So there's a couple of exceptions, including consents. Right, so whereas individual consents was deemed to have consented, again, a concept under the Singapore PDPA, right, to the transfer of personal data to the recipient in that country, and other exceptions. So, where necessary for disclosure under the Singapore PDPA, or if there are, reasonable steps to ensure that personal data will not be disclosed for other purposes, right, or if public, right. Next slide, please. Oops, sorry. Actually, I had another slide, but I had this is a quick run through of my Singapore's requirements, focusing mainly on the regulatory front as well. So to add my personal thoughts on like the issues faced by global companies based in Singapore. So there are many companies headquartered or regionally headquartered in Singapore. And for a lot of the companies, the benefit is that Singapore prides itself as being a diplomatic hub, and we serve as a center for a lot of businesses, a lot of data as well. So that being said, the PDPC has taken enforcement against companies that have breached the transfer limitation obligation, especially if there is a data breach involved. There should definitely be still attention paid to cross-border transfer requirements in Singapore and proving it. If anything, leveraging of Singapore as a hub, in order to facilitate cross-border data transfers in the region or globally as well. So thank you for your time, and for those who wish to connect, my LinkedIn profile is available as well. Thank you.
Thank you, Sandy. So, as mentioned by Chrissy before, I'm Lani Diaz. Although I'm based in Osaka, Japan, serving as a legal director in Shusaku Yamamoto Patent and Law Office. I'm also a senior lecturer in University of the Philippines College of Law, teaching torts and damages, and part of the curriculum is on digital torts. So, just a brief introduction of our company. We do provide services in relation to cyber readiness, incident response, particularly mitigating exposure if there are cyber incidents, as well as regulatory investigation. And most of these services are cross-border in nature. So next slide, please. Today, I think that this is not the updated slide, but that's okay. Today I will be discussing 3 main points. The first one is the extent and the scope of the extent and the scope of the application of Data Privacy Act of the Philippines. And I would be answering 2 main questions. The first one is if in the Philippines we have regulations specifically geared towards cross-border data transfer, and do we have data localization requirements? Next slide, please. Next slide, please. In relation to the scope of the application of Data Privacy Act in the Philippines, the first part that we need to look at, because this will be relevant, particularly when looking at the data privacy cross-border transfer regulations as well as data localization laws, is the principles that's being adhered to by the Philippines. There's 2 parts of the declaration that we basically adhere to. The first one is that data privacy is a fundamental human right. So Philippines adheres to that. And the second one is that Philippines also adheres to the principle that there should be free flow of information. As to the coverage of Data Privacy Act, there is a territorial coverage, but on top of the territorial coverage, there's also an extraterritorial coverage. This means that if an entity, even if functioning outside of the Philippines, they still end up being subjected to the Data Privacy Act, provided that this PICs or personal information controllers would be processing information of Filipino citizens or Filipino residents. So this is a very important fact in view of this is a very important point in view of the fact that even if the processing does not happen in the Philippines, it can still be subjected to the DPA. In relation to the first question, do we have cross-border data transfer? data transfer regulations? The short answer there is no. Usually, the regulations which apply to the data transfer domestically is the same regulations that apply to cross-border data transfer. So there are no specific provisions directed towards transfer of data alone. And in fact, transfer under the DPA is subsumed under processing. And so when looking at the regulations regarding processing and transfer, one looks at the adherence of the DPA to the principles of transparency, legitimate purpose, and proportionality. This is one of the few of the principles that the DPA requires the PIC to adhere to. The DPA also sets out the criteria for lawful processing of personal information. And this lawful processing of personal information, as long as one of the criteria set out is met, then such would be considered as lawful processing. Two of the more common ones would be, number one, getting consent from your data subject. I think that's actually quite a quite known procedure of ensuring that the transfer or the processing is lawful. And the second one is if it is necessary for the purpose of legitimate interest. Now, this legitimate interest requirement is has a 3-tier examination. The first one is one needs to identify if such processing, if the purpose of such processing is lawful, if the processing or the transfer is necessary to achieve the purpose. And the last one is the balancing test, wherein is the interest of your PIC balanced or given much more weight than the interest of the data subject. Now, this particular test is very important because in the Philippines, if you can provide that there is a legitimate interest for the processing or for the transfer, then it can be considered as lawful. Other non-common ones would be if the processing or the transfer is necessary and is related to the fulfillment of a legal obligation or a fulfillment of a contract, if it's in compliance with a legal obligation, or if it's to protect a vital interest of the data subject, such as their life or health. And finally, if it's necessary in order to respond to a national emergency or comply with the requirements of public order or safety. So I think the slides are now provided. I wanted to start off, if you can go to the previous one. I just wanted to start off previous one, please. I just wanted to highlight that the data transfer discussion is very important in view of the increase in the number of the terabytes per second that's being transferred from 2010 to 2019. It's also very important because according to a research conducted by Oxford Economics, digital skills and digital capital is now represents 22.5 of the global GDP, which shows you the importance of having a unified regulation across not just one region, but across the whole world. So next slide, please. As I mentioned earlier, the Philippines is actually falling under the level 1 when it comes to the level of restrictiveness of movement of data. And this is very important because the Philippines, as I've mentioned earlier, adheres to the free flow of data. Now, the moment that there's more restrictions, obviously, then it moves towards the end of the spectrum. According to the IRR, if PIC would be transferring a data to a third party, they need to be accountable to comply with the requirements of the act. This means that they should use contractual or other reasonable means to ensure that there is a comparable level of protection once that particular data is transferred to another entity. Can we go to the previous slide, please? So in the previous slide, I was going to talk about the data localization. So the question was, is there data localization requirements in the Philippines? There is no data localization requirements, at least under the DPA. In fact, in the advisory opinion, the NPC said that at this juncture, it would be speculative for the NPC to provide an answer to the positive question of whether NPC foresees any future implications on data localization, data sovereignty, data protection vis-a-vis the concept of free flow of data. So currently, there's nothing in the DPA. However, it is important to note that there are sector-specific localization, and this can be seen across jurisdictions. One of the sector-specific regulations would be for Department of Information and Communications and Technology, wherein if it's a government data, then there is a residency rule that it must be housed within the territory in the Philippines. That's also the same in Indonesia, wherein localization may be required for certain private corporations, such as banking or financial institutions. So that's my presentation. Thank you very much, everyone, for listening. And if you have any questions, please feel free to contact me or put it in the chat box. Thank you.
Thank you, Lani. Our next speaker is from Japan, and he will talk about the Japan updates on localization and cross-border data transfers. Apologies, Camera-san. In my rush to get into the meat of the webinar, I forgot to introduce you, but let me do it properly. So our next speaker is Daisuke Kamera. He is the managing partner of Shusaku Yamamoto. His practice includes patent, trademark, design, and IP litigation. He has significant practice in regulatory work, particularly on medical devices and healthcare, having been connected as legal counsel of Omron Corporation, including Omron Healthcare Company Limited. So let's now hear from Camera-san.
Thank you for introduction, Isna. Good evening. I'm Daisuke Kamera. I'm a Japanese attorney for almost 15 years. And now I'm talking about action protection of personal information. It's a Japanese name of personal information regulation. And it is established on 2003, and but after that, it is amended in 2015. This regulation stipulated that the regulation have to change every 3 years. So every 3 years, the regulation is changed, and we have to carefully watch about the change of Personal Information Act. And this act is binding business operator. It is a business entity that handles personal information. And yes, and now today we discuss regarding data localization, the cross-border data transfers. And the first, I mentioned data localization. In Japan, Japan Act, there is no requirements on data localization, but when some business operator are handling personal data in foreign country, and means other than Japan, the business operator need to understand the system for protection system of personal information that foreign country which is handled, which personal information is handled, and also take necessary measures to protect the personal data properly. So that is a requirement, that is a regulation in Japan. And next slide, please. Regarding data localization, sorry, please go back to previous page. Sorry. Even this regulation applies not only providing personal data to third party in foreign countries, but also, for example, subcontracting some works to third party in a foreign country. Sorry, please next page. And regarding the cross-border debt transfers, there is 3 ways for transferring personal data. One is a simple obtaining consent from individual which has a personal information, and providing in the when obtaining consent from individuals, a business operator need to information to individuals. That includes a system, so name of a country, and also a system, basically protection system of such overseas, and something like that. And so this regulation also applies not only not only providing third party in foreign countries, but also subcontract some works to third party in foreign countries. And second is providing to business operators that have established a system that complies with APPI standard. APPI is an Act on Protection of Personal Information. It's the name of our Japanese data privacy personal data act. And as other lawyers mentioned, it includes a system certified by Apex CBPR. This is one way of one way to keep establishment of systems that complies with APPI standard. There's also another way to establish a system, and business operator can take other way to establishing such system, but it is so complicated, and yeah, such a this time this so short presentation, I can't mention that all, but it is so complicated, and personal feeling, it doesn't work. And the third way, what's one is to a foreign country that has especially personal information protection system recognized to have equivalent standards to that's in Japan. It means there are EEA areas, European areas, and also UK. When in other words, when we when transfer personal data to such European countries and the UK, we do not need to obtain consent from individual. Yes, and that's all our regulation of our cross-border data transfers. Next slide, please. Maybe that's all. Okay. Yes. Yeah, thank you so much. Yes, that's all. Yes, yeah. Please proceed. Yeah, thank you.
Thank you. I'll be speaking. Hello. Hi, this is Lindsay Zhu. I'm a partner of Square Pattenbach Shanghai. I'm gonna talk about the data localization and cross-border transfer related regulations in China. The cross-border data transfer is highly regulated in China. So we can spend hours talk about this topic. With the limited time we have today, I'd like to most focus on today's presentation on a major update of China's standard contract for data export relating to personal data. And it was just released a few weeks ago and require and impact most companies, especially multinational companies doing business in China. And there is requirement for taking actions immediately and filing. So I'll talk more about that, but please go to the next slides first. Yeah, but before focusing on personal data, I'd like to probably give the audience a bigger picture of the Chinese data protection laws. So Chinese data protection laws governs both personal data and non-personal data. There are big laws like personal information protection laws and data security laws, as well as numerous regulations specifically relating to industrial data, specific type of data, or specific processing. For example, there are several regulations relating to data export, regulations relating to data security review. There are regulations relating to automobile data, commercial, financial data, medical data. So you have to see, not only the big laws, but also various regulations in order to be compliant. There are also a lot of national standards and what we call the national standard, which is really like best practice that provides a lot of technical guidance about how to comply especially from technical perspective. So when we talk about data localization requirement, there are data localization requirement under the personal data protection law and data security law, which apply to so-called important data. So data security law basically will establish a data classification system where data will be classified to different levels. So if it's critical, it's important data, it should be localized. But that's another system here. One thing I may want to specifically point out is automobile data, which I think is a bit unique for China, especially relating to smart cars. When you have smart cars, autonomous cars driving on the street, you have multiple cameras built in the car that will take videos on the street, both inside and outside of the car. China has a specific automobile data regulation to regulate data collecting outside of from environment outside of automobile as well as inside, and those data are usually basically those data have to be stored in China in most of the cases unless special approved is obtained for exporting. Basically, a government security assessment. Now, let's come back to our main topic today, which is the export of personal data. China also has a localization requirement in connection with personal data. So here on this slide, we're talking about what data should be localized. But those data can still be exported outside of China, transferred outside of China, if a government security assessment is passed. So this applies to the following situation. First, the controller is a critical information infrastructure operator, which means the data controller is an operator of a network or a system that is categorized as critical information infrastructure, which refers in most of the cases critical industries like telecom, finance, natural resource, transportation, public service, national defense. So it depends on the nature of the company. And the identification of ICIO is done by government authority. So you'll have a identification if you are a CIO. So it's if a controller is a CIO, then in order to export personal data, it has to go through a mandatory securities assessment. The second scenario is where large volume of personal data is involved, which means 3 thresholds that you can see on the right side of the box, which is if a data controller processes over 1 million individuals' data. Second threshold is if a controller exports over 100,000 individuals' personal data in the last year. Third is if a controller exported 10,000 individuals' sensitive data of the last year. So this is either one, any one of the, if the controller meets any one of the threshold, then it needs to go through a government security assessment before the data can be transferred. Here I want to just touch a little bit on the sensitive data. Sensitive data, the definition of sensitive data in China is quite broad. It's broader than what you'll typically see under GDPR. And it could include the typical like sensitive data under the GDPR, but also include like ID copy, ID number, passport number, your financial accounts, bank account information, geolocation information, and all data of minors under 14 years age is considered sensitive data. Next slide, please. Okay, so if after the assessment, a controller confirms that it does not meet any of the requirement, any of the criteria I mentioned in the last slide, then they can export personal data based on the other means, which as of today, the most effective way is to enter a standard contract that is drafted by the government between the data exporter and data recipient. So this is similar to the US standard contract clause mechanism. But in addition to that, there are also, you'll see on the right side, the box, these are the requirements that needs to be met for data export. First, as a general principle, exporting or transferring personal data outside of China will require specific consent from the data subject. Specific consent means you cannot obtain a consent as part of a privacy policy. It needs to be specified, and you need to get the data subject explicit consent for data export, unless consent is exempted, which is apply in, for example, necessary for performance of contract, necessary for human resource management. This is more about employee data. Necessary for performing legal duties or for public interest. If you are familiar with GDPR, you'll see that a major difference here is China does not have legitimate interest as a basis for processing or as a ground for consent exemption. So this means in more cases in China where you will need to obtain consent for purpose of data export, especially almost in all cases with consumer data. In consumer's case, it's always required unless there is a contract between the consumer and the service provider. The second requirement is sufficient or proper notice has to be given to the data subject with or without consent. And proper notice will need to include the name and contact information of the recipient, the purpose of the data export, so the purpose of specific for the transfer, and the method of processing, the retention period, and if there is a standard contract signed, the data subject is considered a third-party beneficiary under the standard contract, and that needs to be informed. So the data subject in the notice, you have to tell the data subject that they are a third-party beneficiary under the standard contract. That's the standard contract gives a number of rights to enforce pursuant to the standard contract as a third-party beneficiary. So they can also request for a copy of the contract if they wish. So the third requirement is that the data exporter has to do a personal information protection impact assessment. The impact assessment is not just a formality. It's basically a compliance review or gap assessment process. So it requires the controller to do an assessment to sort of in terms of the compliance of the data controller of the Chinese law. And that include, in case of data export, the most important principle is whether the data export is necessary and minimum. So there needs to be a very detailed exercise and evaluation as to whether each type of data is necessary to be transferred, and whether the amount is minimum, and all that. The whole assessment has to be documented in the assessment report. Also, the assessment should cover, the security measures that company has taken. It has to cover whether the company has given proper notice, obtained consent, whether the company has adopted proper policies such as, retention policies, incident response policy. All that needs to be reflected in the assessment report. And that report will need to be filed to the government with the signed standard contract, which is the fourth criteria. Fourth requirement is to enter into a standard contract as published by the government, which was just published, a few weeks ago. And I'm not going to talk about in detail about that, the standard contract, but in general, it's a standalone contract. The parties don't have the ability to amend the contract. You can reinforce it. You can add supplementary terms that's not in conflict with the contract, but you have to sign the contract. There are a lot of details that need to be filled into the contract, and the contract needs to be filed with the government within 10 days after it is signed, and together with the assessment report, as we mentioned. Briefly, there's technically, there's a third mechanism where you can get a personal information protection certification, but at this moment, this mechanism isn't clear. That it seems to be, no like third-party private company has got the authorization to issue the certificate, so it's not really an effective mechanism at this point, but it may become another way of for data export in the future. Next slide. Okay, here I just want to quickly talk about the timing of the new regulation. As I mentioned, the Chinese standard contract was only released a few weeks ago, and it requires the companies or data exporter to file the signed standard contract, and especially the PIA, the impact assessment report, which in our experience would take months to prepare. It is a very kind of detailed review of the processing practice, and importantly, that if there's any incompliance discovered during the impact assessment review process, it takes months to rectify the incompliance. So the regulation will take effective on June 1st, and it will give 6 months grace period to any activities that occurred before June 1st. So essentially the deadline for filing the contract and the assessment report is December 1st, 2023. Just quickly, if there's any change in the future, any material change, processing details change in the future, the standard contract needs to be re-signed, impact assessment need to be updated, and they need to be refiled. That closed my presentation today.
Hi, everyone, and thank you all for making the time to attend this webinar. My name is Natasha. I am a lawyer working at a firm called Russell Kennedy. It's a commercial law firm in Australia with offices in Melbourne and Sydney, and we service clients all across Australia. While I work primarily in workplace relations, I also deal with privacy law in the context of the education sector. Our firm acts for a lot of private schools, and because of the fact that a lot of the information that they deal with is now stored in the cloud, they do need to be very mindful of these sorts of regulations. So today I'm going to be talking with you about the current laws in Australia relating to data localization and cross-border transfers. I will also be talking about the connection between human rights, privacy, and data protection. It is cliche to state that knowledge is power, but it is. This is most clearly seen in the area of privacy and data protection law, and in case studies of what can go wrong. In October 2022, Medibank, one of the largest Australian private health insurance providers, was the target of a cyber attack. Hackers accessed and stole the personal data of over 9.7 million Medibank customers, This was one of the largest data breaches in Australian history. And the information stolen wasn't just names and contact details. It also included what medical treatments had been accessed by customers and from where. A group of hackers claimed responsibility. They threatened to publish the personal medical information of high-profile politicians, actors, social media influencers, and LGBT activists online if Medibank refused to pay a ransom. Medibank ultimately did not give in, and the hackers actually published the customer information on the dark web. This included information about insurance claims that people had made from Medibank relating to abortion procedures that they'd had, and also alcohol and drug abuse treatment that they had received. During this time, Medibank opened a mental health support hotline for all customers affected. Some news articles that were published around that time also carried taglines with the phone numbers for free crisis counselling services because this breach affected so many people within Australia. Knowledge, information, and data is power. I'll come back to this later. Before I go on, I want to give you an overview of Australia's privacy and data protection laws. Australia is a federation of 6 states and 2 territories. So we have federal laws passed by our federal parliament, but we also have laws passed by each of the state and territory parliaments, which apply only within that state or territory. Federal, state, and territory parliaments can all make laws regulating how personal information is handled. At a federal level, the Privacy Act is the primary law that regulates how personal information is handled. This is what I will largely be focusing on today. In the private sector, the Privacy Act generally applies to businesses with an annual turnover of more than 3 million Australian dollars, which are carrying on a business in Australia. So these laws can actually apply to overseas-based companies too, provided that they are conducting some sort of business activity inside Australia. The Act sets out 13 Australian Privacy Principles, or APPs. The APPs are a set of rules for how businesses, called APP entities, must collect, store, and use personal information. An important thing to note is that there is currently no distinction between data controllers and data processors in the Australian Act. Next slide, please, Jing. Thank you. There are no specific requirements in the APPs regarding data localization per se, but there is, however, a transfer limitation, and it's set out in APP number 8. APP number 8 relates to cross-border disclosures of people's personal information. It says that before an APP entity discloses personal information about an individual to someone, a recipient who's located overseas, the entity must take reasonable steps to make sure that the recipient complies with the same APPs. If it fails to do so, the APP entity will be liable for the actions of the overseas recipient as if they were its own actions. There are a few exceptions to this rule, but the 2 key exceptions are this. 1, if the entity reasonably believes that the recipient is subject to legally binding rules or a legal scheme that give the same level of protection as the APPs. The level of protection must be substantially similar, and there must be some mechanism for individuals whose personal information is being sent overseas to actually enforce those rights and protections. Number 2, if the APP entity asks the individual, can I send your information over to this jurisdiction? and the individual says, yeah, okay, go for it. Other than the APPs, there are laws at both a federal and state level that require some level of localization of certain types of data. These laws deal with data that is typically either health information, credit or financial information, or relevant to the country's national security. So you can see here that localization requirements are quite concentrated on information that is either highly sensitive from individuals or information that has some sort of consequence for our national security and national sovereignty. Why is it that this is the case? The answer is that it's because Australia is a very open and highly globalized economy. We have many trade links to Asia. Our minimum wage within Australia for employees is 20 Australian dollars per hour. So our businesses are very heavily dependent on the ability to outsource work and the data that is necessary to do that work overseas. At the same time, we are a society that values individual rights and freedoms very, very highly. Our privacy laws therefore aim to strike a balance between allowing the free flow of information across international borders to allow us to do business and respecting the privacy of individuals, very much like the situation in the Philippines. When you look at it through this lens, it is easy to see where future reforms might take us. So, what are we likely to see in future? Our Attorney General's Department has recently conducted a review of the Privacy Act and basically recommended a complete overhaul. In relation to APP 8, it has recommended a number of changes aimed at making it easier for businesses to comply with requirements about overseas disclosures. Currently, an entity disclosing information overseas needs to make sure that it takes all reasonable steps to ensure that the recipient complies with the APPs, unless there is an exception. Usually, this would mean that the APP entity enters into a contract that says the overseas recipient will comply. But it is very unclear how such a clause could be worded. So a recommendation is that standardized clauses be made available for APP entities to use in their service contracts with overseas recipients. Another issue is that it is often difficult for entities to tell whether they fall under one of the key exceptions. Because, to be honest, it is difficult to tell whether another country provides substantially the same privacy protections as the APPs. Most lawyers will tell you that it is difficult enough keeping up with the laws of your own country. So, a recommendation is that Australia should introduce a process for prescribing certain countries and certification schemes that give equivalent protections to Australia. This would operate in a way that's similar to how the EU adequacy decisions currently operate. This type of change to the law would give businesses much more certainty about whether or not they are in fact complying with the APPs. However, there is also a trend towards increasing protections for individuals. The technology that is now available to gather data is advancing at a rapid pace. It is matched only by the growing willingness of individuals to give over their data, often for free, often with zero thought about where it's being sent, who sees it, and what the privacy notice on the website or mobile phone app says. There is a growing awareness that having such volumes of information about individuals can give an organisation immense power. In November 2022, the federal government passed changes to the Privacy Act to impose harsher penalties for serious or repeated data breaches. The maximum penalty for these types of breaches is now the greater of 50 million Australian dollars, 3 times the benefit that was gained by the breach, or 30% of a company's domestic turnover. This was a direct result of the Medibank data breach and another data breach affecting one of our telecommunications providers, Optus. And in the Privacy Act review, a recommendation has also been made to require entities to consider the risks of overseas disclosures and then tell individuals about the impact of their consent before the consent is provided and valid for the purposes of the exception under the law. So while there may be resistance to general data localization laws within Australia, that's not to say that the rights of the individual are completely being disregarded. Next slide, please. In Asia, data protection laws are most often relevant in a business context. However, it is important to be aware of the role that they play in supporting the right to privacy. The Universal Declaration of Human Rights states, "No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attacks." The right to privacy is known as a gateway right. This means it allows the free exercise of other human rights by placing restrictions on the type of information that can be held by any one organization or entity and how they can use that information. By making sure that no one can hold your personal information, your political views, your medical history, or your religion over you. Privacy and data protection laws are critical to preventing the persecution of individuals by well-resourced institutions, whether public or private. And it is very important to keep this in mind when seeking to understand these laws and also in reviewing any proposal to change them. So that concludes my presentation. Thanks very much for listening.
So thanks so much, Natasha, and to all the panelists. My name's Scott Warren. I'm a partner with Squire Patton Boggs, and I look after data privacy across the region. So I've been asked to kind of give a couple of thoughts about the broader perspective on data privacy obligations. I'm based in Tokyo, but also in Shanghai, where I'm working with Lindsay on a lot of the really hot China data privacy issues that have just boiled up. And so what I wanted to do, and really all the panelists have done a great job of identifying specific country laws for many of the countries and laying out kind of the patchwork of this quilt for APAC region of the data privacy laws that apply. I just want to add a few more pieces to that quilt very briefly. You know, Thailand has a data privacy law now in place that is very GDPR-like in many ways, but has a couple of different twists and turns that apply. South Korea has a long-established, very strict data privacy policy. Indeed, a lot of my South Korean colleagues claim that GDPR stole its ideas from Korea. Korea has a 24-hour notice rule for breaches. So if 72 wasn't early enough, Korea has this 24-hour. And there have been some really interesting updates with the Korean law lately, which has just gone through in the last few months. Some of them in you know, are an effort to comply with the data adequacy finding between Europe and Korea, but a lot of them just to consolidate a lot of different things. So South Korea is an area of focus. And then really interestingly, Vietnam has a data privacy law, which has some localization requirements. And I just wanted to point out really quickly, if you're an entity doing business with Vietnamese customers through e-commerce, SNS, online gaming, email services, or quote, others that analyze personal data about users in Vietnam, You are required to establish an office in Vietnam, store personal information and other important data in Vietnam, do security assessments before any data is transferred abroad, and ensure that your technology meets certain qualifications. So in essence, what I see across the region, and frankly, let's do this from a broader perspective. The way I think it's helpful sometimes to think about data privacy is on a global basis. I came up with this concept a little bit ago that I think applies. And that's that data privacy in Europe is fundamental human right. We heard that spoken through with Philippines and certainly a number of countries in the region, but it's considered a fundamental human right and protected as such. I look at the United States as looking at personal data as a fundamental corporate right. It's the right of the corporations that collect it, but God forbid you lose it because the penalties are high for breach, loss, and also that you abuse it. You do things with the data that you haven't properly announced, because again, the penalties can far exceed even what you will see in Europe. And then I think if you look at China's laws, Russia has the similarities, and even Vietnam. I think that they look at personal data as a fundamental state right, essentially, and that the desire is to ensure that the data is localized and kept in order to, in many ways, protect state interests. It's wrong to consider that this is a spectrum. It's not that any one of these things is wholly unique, or Europe only looks at it as being a fundamental human right and not interested in state rights. The Schrems cases show that they're very interested in who has access to this data abroad for security reasons. The United States certainly is looking at it as the corporate right, but the United States has proven with Huawei and a number of other cases that they very much want to protect the colonial pipeline and other types of issues from a national and state basis. And then China is certainly focused a lot on these state rights, but they are a broad set of rules that allow individuals to have rights that have access and all sorts of things that are typically provided for under the GDPR. So if we look at this in that framework, it's a lot easier to see, okay, this law is like this. A lot of the rules that have been passed throughout the APAC region all agree with data subject rights, consent, or some other format in order to properly collect, process, and then cross-border implications come after that, to have subject access requests, to have breach notifications. And so if you kind of look at it that way, then I think it's easier sometimes to go across how do you implement a policy that can apply across the region. So with that, I'm going to just turn to a couple of Q&A items. I was really interested with both what I read in the Philippine and also the Vietnamese Act. So this is more to Lonnie. I read that law. So most countries now are saying this law applies to anybody within our country borders. And then it's starting to say, if you collect data from outside the country and collect data about individuals within the country, then you're going to be subject to our law. Under the Philippine law and the Vietnamese law, I saw that it also applies to any Filipino, Filipina, or Vietnamese citizen living abroad. So if you're a Filipino living in Los Angeles, the Philippine data privacy law actually is supposed to apply to it. Maybe you have a different view to that. I'd be really curious if there's been any enforcement actions in that area and what you think about that.
Thank you, Scott. As far as I know, there are no enforcement actions in relation to that. But I think one important point, though, that PICs should be aware of, especially those PICs collecting information, personal data about Filipino citizens, is if you're collecting data in relation to specific sectors, there are requirements to register. And so I think that this extraterritoriality, and it's not just in the Philippines, actually. I think you're also going to see this requirement in Japan. There are certain restrictions wherein the Japanese law might apply to data collected. And so the conflicting issues or the conflicting regulations when your PIC, especially PICs doing multinational business, is something that's going to be difficult to address. One of the things that I've seen in our for our clients, if they have a privacy regulation, a privacy notice in place, a certain privacy notice, even just for the right of data subjects, a certain privacy regulation that applies to a company operating in the United States, for instance, they will have legal, those regulations or those provisions would be considered legal in their jurisdiction. But the moment that they start collecting data of Japanese nationals or collecting data of Filipino nationals, some of the provisions would no longer be considered legal. Although, as I said, there's still no regulation. One thing that I want to point out is the fact that in the US, you will see a lot of PICs who is now imposing cost of business for modifying or even deleting particular personal data of the data subject. But once you try to implement that particular provision in the Philippines, for instance, in view of the fact that the framework in the Philippines is that of a human rights, meaning data privacy is human rights. If you're imposing a cost on your data subject, then that's something that's not going to be, it might be considered as a diminution of the right. So again, it's an important point. It needs to be discussed. I think there also needs to be a lot of awareness, especially if you're doing business, covering Filipinos outside of the Philippines. But so far, no enforcement has been done.
Great. Thank you.
Block.
The next question I actually wanted to first pose to Lindsay, and then we can broaden it out if we have enough time. I think we do have a little more time. And the issue is really this, the China law to me is the scariest new law that's out because it applies to every single piece of personal information you want to get out of the country. I'm getting a little bit of feedback, so if we can make sure everybody that's not speaking is on mute, that's great. So I mean, and the penalties, we saw China impose a $1 billion US dollar penalty on a Chinese entity recently, largely in part to the PIPL data privacy. So, and they can shut down business and otherwise. So Lindsay, how do you go about really complying with that law? And then I'd like to just extend it out. How do we, to others, how do we end up creating a framework that allows us to help our clients when they have data in multiple countries, whether it's APAC, Europe, or US, and how can we do those parts? Lindsay?
Yeah, Scott, I agree. I mean, the new regulation is very created a heavy burden on especially multinational companies operating in China. So even you have just one employee in China, that means you need to go through that filing impact assessment process. But just get back a little bit. So impact assessment is required, even if it's not under the PIPL, it is required to do. And it's not only required for data export, it's also required for processing sensitive data or transfer data to any third party, even within China. So it's not a new requirement, but now it requires a filing that makes every the timing becomes an asset. So it becomes an urgency for the company to comply. I think the new law, the purpose of the new law, that was controversial at the time it was the draft was published. But I think in the final draft it's still there. And I think the reason is for company to push the company to comply. Data export is in some way sensitive in China because I think largely because there's national security concern. And as you know, with the geopolitical difficulties, China has been concerned about not only personal data, but also critical information that has national security concerns. So I think that's that's the underlying reason for more sort of strict data transfer and data control regulations in China. So in terms of and the Didi you mentioned, the 1 billion fine is a good example because the company that was fined is basically China Uber, and it has all the passengers, the tracking information, where they went, and it also has cameras inside the cars that basically they can take video. So the government is very concerned of the data Didi collect. So it's not only personal data, but cybersecurity and national security reason. And that is, and Didi refused to. So the background is Didi wants to get listed in the US, and the Chinese government told them, hold on, we need to do a data security assessment before you can get you can go listed. But Didi refused, so they secretly got listed in the US, and which was found by the government later, and that makes this historical high, and it was this historical high penalty, which equals to 5% of their turnover in China. So I think in terms of enforcement, China actually is very active in terms of enforcement relating to consumer data. So protecting consumer data is a top priority of the Chinese government. So I think for companies doing business in China, you have to keep in mind that if you're dealing with consumer data, you have to be very sensitive. If you have apps in China, China has special regulation relating to mobile apps, relating to websites, relating to mini programs in WeChat. So, and there are thousands and thousands of mobile apps has been suspended because of breaching the privacy laws. So consumer data is top of priority for companies to comply. And so as a general principle, I would not recommend companies to export consumer data. For employee data, on the other hand, this is more for internal company management and HR management. I think generally it's okay as long as you go through the process. So it's really just for the companies to do the impact assessments as soon as possible, get the contract signed, make a filing.
So I think I've run us all out of our time for at least further questions. If you want to find out how to make it work across the APAC region, you either have to turn in for the next one or just reach out to one of us, and we'll share with you lots of wisdom in that. But I want to turn it back to Priscilla for any other questions that she might have, and also for our closing comments.
Okay, I think there are additional inputs from Sandy. Maybe we'll call on Sandy, and then we could close after that. We'll just apologize that we don't have enough time to address all your questions, but feel free to send your questions to the speakers with the contact information earlier provided. Sandy?
So maybe, as you know, since I am representing, or I'm from the in-house community here, we actually have to deal with a lot of these like merging data localization questions, cross-border data transfer questions internally as well. And increasingly, I think, right on the spotlight of today's topic, we have the TikTok Congress hearing earlier today or yesterday, depending on time zones. And it really highlights the difficulty that this topic has in today's age. I would say that even, like maybe 3 to 5 years ago, when you talk about data localization and cross-border transfers, the kind of reaction you get from regulators is different, right? From today's climate. I think post-COVID, you see a kind of a nationalization of a lot of policies and stuff like that. It also makes a lot of the compliance requirements additionally hard. So it's not just, the data localization portions, like Japan has their very strict consent requirements, and then it kind of sometimes works against, the transparency that we want to bring to users as well, because then we have more things that we need to seek consent for. And operationally, it's a challenge because what if people withdraw consent, and the reality is that the internet is a big place, and data servers are working globally, right? So you see a shift, right, in TikTok's issue itself, setting up separate servers, in the US, separate, in the EU. Sometimes it's also not a solution, an answer, not the answer that regulators want to look at. So if anything, my job has shifted more from a in-house compliance kind of approach to really looking at what regulators are actually interested in, right? So that's the interesting part of this topic in today's age. Yeah.
Thank you for that, Sandy. So I think it's clear to us that there are different regimes for every jurisdiction. So I think the challenge to all of us, and maybe it's ripe for, another webinar, is how to harmonize those conflicts. How do we comply and how to defend our clients in the event there's any enforcement action, right? So maybe to close, we'll call on Dr. Sunil, please. Thank you.
Thank you very much. Thank you very much to all speakers, my good friend Johan, Sandy, Lani, Daisuk, Lindsay, Natasha, and Scott as well. During this discussion that we were educated on how to deal with data localization and cross-border data transmission between jurisdictions in this region. Considering time factor, I will limit my closing remarks, mainly that as far as all these jurisdictions, your presentations are concerned, we must know that each jurisdiction has introduced these laws relevant to privacy policies and data protection, considering their own socio-economic, political, and cultural reasons. So that is why we can see some differences as far as these jurisdictions are concerned. But when you look at international trade and commerce, it's high time to maintain some standards, at least minimum standards, as far as data protection or privacy policies are concerned. So we have 7 principles under GDPR, because the GDPR was introduced in European Union considering their own socio-economic and political reasons. As far as Asian countries are concerned, we can see lots of differences. We have our socio-economic and political background. So therefore, when you look at especially Asia-Pacific region, it's high time to consider the standardization of these data protection or privacy policies. This must be our final task. So if we maintain different policies, different laws, so it is difficult to run international business. Some countries have already started to harmonize the situation, introducing bilateral treaties. So it's high time to introduce either model law relevant to all countries in the world, or convention relevant to data protection or privacy policies. With that thought, may I invite all of you to join our Law Asia Data Protection, Communication and Technology Committee. We are in this mission. Our main target is to standardize the data protection laws and privacy policies in the region. I hope that you will join us. Once again, thank you very much for Philippine Bar to organize this wonderful webinar. And we learned a lot. We got a lot of experience from your jurisdictions. Then once again, I must personally thank all of you to give me this opportunity to make my contribution.
Thank you, Dr. Sunil. Thank you, everyone. Thank you for this landmark collaboration between the PBA and Law Asia. So we're truly international, right? So thank you, everyone. And I think we'll be playing the PBA hymn. Thank you, and we hope to see you again at our future events, maybe in person, right? Thank you.
Chrissy, let's have a picture taking.
Okay. For those who can turn on their cameras, please. Thank you. Jing, let us know if it's done.
Can everyone turn on their cameras, please? Thank you.
Not sure if the screen's going to be able to take 90 different thumbnails.
I'll take 3 pictures. Please turn on your cameras. Thank you.
That's gotta be enough.
Okay, I think we're good.
Thank you, everyone. Happy weekend.
Thank
Happy
you.
Thank
weekend.
you. Thank you, everyone.
Thank you so much.
Thank you. Thanks.
Thank you.
We are the PBA, heirs to a glorious past, in dread and noble purpose, to blaze the future's path. Let us be the shield against lies and oppression. Let us be the light to bring justice home. Through time we have stood constant, faithful to our own, champions of the oppressed, guardians of the truth.